Welcome to the revision lecture series by MP Siddhesh. This is part 4 or the final part of the revision lecture series on legislative relations. We have covered all the subtopics related to center-state relations or legislative relations in this series. Therefore, I highly recommend watching all the parts in this series for a complete understanding of the topic. In this part, we shall cover the following topics: parliamentary legislation in state field, and finally, the rule of occupied field. Let us start with the subtopic of the parliamentary legislation in state field. As the name suggests, parliamentary legislation in state field includes the situations in which the parliament, that is the central legislature, becomes competent to legislate with respect to matters in list number 2, that is the state list. Parliamentary legislation in state field involves temporarily ignoring the separation of powers which exist in a federal system on account of some extraordinary situation which must be taken care of at the national level. So, the Parliament can legislate with matters specified in the state list in the following situations. Number 1, under Article 249. Number 2, under Article 250. Number 3, under Article 252. Number 4, in order to implement an international treaty. And finally, in case of a state emergency or imposition of President's rule in a state. Now, let us first look at Article 249. According to Article 249, the Rajya Sabha may pass a resolution by two-thirds of the members present and voting, empowering the Parliament to make laws with respect to any matter in the state list or list 2 specified in that particular resolution. Such a resolution passed under Article 249 remains operative or effective for 1 year at a time but may be renewed from year to year without any limits. A law enacted under such a resolution under Article 249 ceases to be operative or becomes automatically inoperative after 6 months from the lapse of the resolution or after 6 months from the date on which the resolution ceases to be effective. The Parliament can also legislate with respect to matters in the state list under Article 250. According to Article 250, the Parliament is empowered to legislate with respect to any matter enumerated in the state list during the proclamation of an emergency under Article 352. Provisions in such laws which are ultra vires of the Parliament or which are outside the competence of the Parliament but for the existence of an emergency shall cease to be operative or shall cease to be effective 6 months after such a proclamation of emergency under Article 352 is withdrawn. According to Article 252, the state legislatures of two or more states may pass a resolution empowering the Parliament to legislate upon the subject which falls under List 2 or the state list which has been mentioned in such a resolution. It must be remembered that approval of the governor of a state is not necessary for passing a resolution under Article 252. Next, it must be remembered that passing of a resolution by a state legislature under Article 252 amounts to abdication of legislative powers by the state in favor of the Parliament. This means that the state legislature is no longer competent to pass any laws with respect to the matter mentioned in the resolution passed under Article 252. Parliamentary legislation in the state field can take place in two more situations. They are Number one, for the implementation of an international treaty within the country. And number two, during the imposition of President's rule or during the existence of a state emergency under Article 356. We have arrived at the final subtopic of this revision lecture. The rule of occupied field is a very important rule which is often ignored by the students while solving problem questions. So, let us take a closer look at the rule of occupied field. First and foremost, this rule is only applicable in the case of conflicting laws made under the concurrent list. According to this rule, when the Parliament shows an intention of occupying the whole field or the entire field with respect to any matter in the concurrent list, it becomes forbidden for the state legislature to legislate with respect to that matter. When the Parliament enacts a complete code which is exhaustive and capable of application all over India, any conflicting law which is enacted by the state legislature becomes overshadowed or superseded by the central law. In other words, conflicting provisions of the state law are declared unconstitutional and become ineffective or inoperative. Let us discuss two important cases related to the rule of occupied field to become more familiar with the concept. Bajnath Kedia was an important case pertaining to the rule of occupied field. The Parliament enacted the Mines and Minerals Regulation and Development Act 1957, which is also known as the MMDR Act, to take over the entire field of mining industry throughout India. The Bihar legislature enacted the Bihar Minor Mineral Concession Rules 1964 and also Act number 4 of 1965, which made some changes to the rules contained in the MMDR Act pertaining to mining leases. The competence of the Bihar legislature to change the rules related to mining leases was challenged before the Honorable Supreme Court. The Honorable Supreme Court held that when the Parliament declares that the law passed by it shall occupy the entire field related to a specific subject, it shall not be competent for the state to legislate with respect to that particular subject. Therefore, any law passed by the state legislature which entrenches or trespasses upon the field occupied by the parliamentary law will be invalid. If the state law falls outside the occupied field, it will be valid. So, in this case, the Honorable Supreme Court held that the concerned changes made by the Bihar legislature to the rules related to mining leases were ultra vires of the Bihar legislature and hence they were invalid. It must be noted that this was a case decided in 1969 and a question may arise whether the Supreme Court holds the same view or the judicial interpretation has undergone a change. In order to answer that question, the Supreme Court has quoted the case of Bajnath with approval in the recent case of Sandur Minerals and the state of Karnataka, which was decided in 2010 by the Honorable Supreme Court. Therefore, the present position is that the rule of occupied field is still good law and is still applicable. Next, we shall briefly discuss the case of TKVTSSM Medical Education and Charitable Trust and the state of Tamil Nadu. In this case, conflicting laws were enacted by the Parliament and the Tamil Nadu legislature related to recognition and affiliation of medical colleges. In this case, it was contended that in fact there was no repugnancy between the state law and the central law and that both were capable of being observed. The Honorable Supreme Court rejected this argument and held that the Parliament has clearly shown the intention of occupying the entire field related to the recognition and affiliation of medical colleges throughout the country, and therefore there is no scope left or there is no space left for the application of state law. Therefore, Section 10A of the Indian Medical Council Act was held to be superior to the concerned provision of the law enacted by the Tamil Nadu State Legislature. And with that, we have finally reached the end of the topic on legislative relations. So far, we have covered the following subtopics: the concept of federalism, separation of powers, territorial jurisdiction, the three lists, the doctrine of repugnancy, the doctrine of colorable legislation, the doctrine of pith and substance, residuary powers of the parliament, the doctrine of severability, the doctrine of eclipse, parliamentary legislation in the state field, and finally, we have also discussed the rule of occupied field. I am fully confident that you can now answer absolutely any question in any form related to the topic of legislative relations. Please feel free to watch and rewatch all the parts until you get a complete understanding and confidence about this topic. Thank you for watching. I am confident that you have understood the entire topic of legislative relations or center-state relations. We upload 2 new videos every Tuesday and Saturday, and you can request for a particular revision topic and we shall try to cover the same as much as possible. If you like the content, please like this video and subscribe to the channel. It shall help me immensely. Thank you once again.